Good morning, good afternoon, and good evening, depending on where you are. This is Richard Greenberg from Los Angeles. I'm the president of ISSA Los Angeles. We're a not-for-profit organization of InfoSec professionals. We have some IT folks as part of our community as well. And today we will have a very special meeting, but a little bit more about ISSA, just so you know who we are. We're the founding chapter of ISSA, which is an international organization. We're in countries all over the world, and we are the founding chapter, as I said, founded by two women. And I find it ironic, I've said this before, because we still don't have enough women in the field. And these two women will go down in history, but we need more. So let's all make sure to keep a welcome and open environment for all of our people, regardless of their sex, religion, or anything else. Very important. These are the board of directors. These are the folks that help bring you these meetings, as well as the famous Security Summit, which we did not have this year, sadly. But hopefully in 2021, things can start opening up a little bit, and we can, have drinks and networking on those important conversations that we have with each other to help us formulate our strategies to help protect our environments. So a big shout out to these great people, without whom none of this would be happening. So really appreciate their help. For those of you who want to stay current with our notifications, so you don't miss any meetings or special events, please visit us at ISSA-LA.org. And there's a little button there so you can receive our notifications. We really don't send much out. It's not spam, don't worry, but you'll stay connected with your fellow InfoSec peers and be able to come to more of the meetings and see what we're up to. And we always love feedback as well. So please, some comments in there to help make us a better organization. And these four companies have helped do that as well by providing discounts on their services to our membership. So please take a look at them when you get a moment. And a big thank you for them for doing what they do for us and our community. Much appreciated. If you want to stay in touch with us, we do post some interesting things. We try to keep up and select important articles and news, and we even do some of our own posting. We would like you to share with us. Everyone listening to this probably has something that they can contribute that would make me wiser today. So I encourage you all to join us on the major social media platforms. If you're under 30, we even have this thing here. What is that called? Yeah, okay. And for those of you who want to continue joining on this as we move forward in time, December and January are special months because we're having two events in each month. And December 30th, it's more of a social gathering. We felt it was appropriate considering the incredibly difficult year that many of us have experienced in 2020, that we want to kick 2020 out the door and have a good happy hour with drinking and talking and even singing. So we're using a platform called Discord, which has multiple rooms, and you can pick the room you want based on subject matter. You can dance around back and forth to different rooms, and the subject matters will be mainly non-work related, just because we want to have you in the right frame of mind. But if you want to talk about something related to security or privacy, that's fine. So there will be I think 5 different rooms, something like that. It should be a lot of fun. I think we all need this. Again, we're missing that networking. This is about as close as we can get to that. So please, if you sign up on our mailing list, you'll get notifications of how to register for that. But the registration is free. If you just go to ISSA-LA.org now, you'll see an event page for that, and there'll be a link taking you over to Eventbrite. So please consider it. We're also going to have a special meeting in January on the 8th, analyzing the attack life cycle in the cloud and dissecting a real world attack. That should be quite fascinating. And on the 13th, we're going to have a law enforcement panel. We have people from Secret Service, FBI. So that should be quite interesting. I'm sure they'll talk about the latest, and I was going to say greatest, but they certainly are, the latest hacks and the latest issues, and perhaps even how how you can help defend yourself and your company from some of these, and how things are looking in 2021. A reminder for those of you who have come to our meetings in the past, you know that we encourage participation. And so you can type your questions in either anonymously or with your name as the panel speaks today. And they said that they will be monitoring it. And if you just go to this site, app.sli.do or slido.com, which will redirect you, and just enter ISSA-LA, then you can type your question, and this panel will do its best to address it. Can't get to all of them, but we'd love you to participate. So now we're getting to what you're really signed up for, not to hear me speak. So I'm going to go away, but before I do, I just want to thank all of our participants in this, what should be a lively and great discussion, because this is really, if you live in California, this is really important. And I'm guessing a lot of you are not quite sure, if you're meeting this, or will you be able to meet it, and the things that you'll have to do moving forward is important legislation. So I want to thank Brad Kelso, who's our moderator. He's the co-founder and managing partner of Privaggio, and a Southern California data privacy solutions company. It helps companies comply and optimize privacy operations for increased revenue. He's also the co-founder of Privacy OC, a nonprofit LinkedIn community of over 500 members for exchanging best practices in data privacy. But the most important thing is he's a good guy. And I want you to know that. And we're all ready to get going here to hear this wonderful panel of Brad. I'm going to hand it over to you. And thank you, everyone for joining. We really appreciate it. We're looking forward to this.
Well, thank you very much, Rich. Really excited about this panel, as you'll find in a couple of moments. This is top shelf, folks. So you're going to get some great insight. And so I'd like to introduce the panel. We have four, and I will start with ladies first in alphabetical. Welcome, please, with me, Karina Clever, who is the founder of Clever Compliance, who has built this business based on her broad 30-year foundation track record in IT management. Clever Compliance helps companies establish a mature data governance by applying best practices and experience-based principles across all functional areas. Many of you already know Karina because she is also an ISSA-LA advisory board member. So welcome, Karina. Thank you very much. Second on the ladies list, welcome, please, Lily Lee, a privacy and cybersecurity attorney and the founder of Metaverse. If you've not been privileged to join or hear Lily speak in the past, you'll be tickled with her insights here. She's a certified information privacy professional for the United States and Europe, and is based here in Orange County, and is also the Orange County chapter chair for their IAPP. She has a long list of credentials, but that would take another half hour. So thank you, Lily, for joining us. Third up, sticking with the ladies and holding off on Brandon. I think it might be an hour before we get to Brandon. But here we are, Sadia Mirza, excuse me, an attorney with Troutman Pepper, an up-and-comer, leading the firm's cybersecurity, information governance, and privacy practice group. Sadia has extensive experience in cyber law privacy, and I love this about her as an attorney. She's handled a number of data breaches and investigations across many industries, healthcare, financial services. I don't know if you've been following the news, but this malware breach thing is out of control. I'm sure her business is going boom. And lastly, welcome the gentleman with this. Is that, I can't even see, but it's the best background I've ever seen. It's kind of like the neon light sign. Brandon Riley is a partner at Manat, Phelps & Phillips, and a practicing privacy and data security attorney and civil litigator at Manat's Orange County office right here in Costa Mesa. Brandon counsels clients on a wide variety of consumer protection and privacy matters, including data privacy compliance incidents and breach response. So I think you can tell by this high-powered group that we're going to get some pretty good advice. Before we get started, this group curated but you're here for, are we ready? So this group already curated a number of topics having to do with CPRA. And I wanted to make you aware that we've organized this webinar to provide a fairly broad view of CPRA and yet you're probably going to have questions. So I want to reiterate what Rich mentioned, which is slido.com, Slido, sly-do.com is a place to enter those questions, and we'll try our best to get those questions answered during the topic. There's nothing more frustrating than having to wait all the time. Of course, we can't handle every question, but we'll do our best. So without too much further ado, let's kick it off a little bit. And I'll start. As many of you recall, on November 4th, Californians and the whole nation awoke to a post-election day with a newly approved privacy ballot measure, otherwise known as Prop 24, the California Privacy Rights Act. And it was actually sort of referred to by many as CCPA 2.0. The CPRA amended certain provisions of the landmark 2018 California Consumer Privacy Act, CCPA, which went into effect last January, well, actually this recent year, and subject to enforcement in July 2020. Specifically, CPRA has now introduced a number of new provisions and concepts to the law that regulators are still fleshing out and businesses are struggling to understand. And so, like CCPA before it, CPRA has created a supplementary group of new regulations to be issued, and this time with a new privacy agency. One thing is for certain: the extent of CPRA's regulatory mandates far exceeds that of CCPA. They have really filled in the blanks here. So let's turn our attention to our experts to help us kind of break it down into bite-sized chunks for us business folks. And I'm not the attorney, but we certainly have some of the best on. So Brandon, tell us a little bit about the new dates of this thing. It's all over the place. It's got more dates than I had in college included here.
You had that one planned, didn't you, Brad?
I totally did. I only had 5 dates in college.
So first of all, I'm speaking through a headset, which is much better audio quality, but it's chiming that it's running out of batteries. So if it runs out of batteries, I'm going to switch. So just hang with me if that's what happens. So yeah, I really think the most important thing to know, at least right now, is that the CPRA is not effective immediately, or at least most of the provisions are not. So we don't have. It's not an absolute freak out, right? So I think the best way to look at it, and what I often say is that if you go back 30 months, from today, if you go back in time, that's when the CCPA was first passed, and in that time period, we have had the CCPA go online. We've had draft regulations go back and forth. We've had them finalized. We've had the enforcement date. So a lot has happened if you look back 2.5 years. Looking forward that same amount of time, so the next 30 months forward into the future, is when the CPRA will finally be enforceable. So we have roughly the same amount of time that we've been living with the CCPA to get ready for the CPRA, which is all great news, of course, for you and your company. But this stuff is going to happen quickly, and many of these things, as the rest of our panel is going to go over, can be pretty heavy lifts, especially depending on where your organization is on CCPA. So what are the key dates? Today, it was actually the CPRA was officially certified and enacted under its own provisions. So happy birthday to the CPRA. We're expecting in March, or at least by March, the new agency will have its members fully named and appointed. So we'll know what kind of the makeup and what direction the government is going in, and what that agency is going to look like. From there, it's really a matter of success of July 1st. So July 1st, of next year, 2021, the agency will start the rulemaking process. So they'll start issuing draft regulations that are actually implementing the text of the CPRA, which is what we have today. That's going to go on for 1 year. July 1st of 22 is when those regulations are due to be finalized. In the middle of that time period, there's a very important look back date, January 1st of 2022, where data collected starting on January 1st of 2022 will be subject to the CPRA when the CPRA becomes effective. So on that date, the law will not be effective, but data collected is potentially subject to rights that Californians will have once it is effective. And then finally, January 1st of 23 is when the law becomes operative, but it does not become enforceable by the new agency until July 1st of 23. So a lot of dates, it's a little confusing, but I think if you think about it in terms of, your July 1sts of the next 3 years, you have big major milestones to be watching. And in terms of, just trying to get our arms around what it's going to take to implement these things, look backwards, look at what was your experience with the CCPA from the day it was passed in July of 2018 until now, and you're going to be looking at roughly the same time period going forward.
So this look back thing sort of scares me. This is January 1st, 2022, which is actually about 13 months away or a little less, right? So as a company, what do I have to do to respond to that look back? It's a 12-month look back on the data. Give us a little more guts on that problem as a business.
Yeah, so really what this is most tied to is data access or right to know requests under the CCPA only have to go back so far, right? They only have to go back about 12 months. That's changing under the CPRA. It's going to change to this kind of longer of 12 months or dating back to January 1st of 22. So data collected after that date is going to be potentially relevant or responsive to a right to know request that is received once the CPRA later becomes operative. So really the operational kind of need is to be able to flag that data and treat it a bit differently because different new obligations are going to attach to that data in the future.
What about budget governance? Is there going to be enough money here at the state level and the organization for enforcement?
Yeah, great question. And one way to answer it is that there's never enough budget, right? There's never enough money. I think the folks in government will certainly tell you that. But they are funded with an initial grant of $5 million, and then each successive year it's another $10 million, and then they'll be able to draw from enforcement penalties and from that fund. So when you compare it to what we've had, it's a significant increase in funding for privacy-specific enforcement and regulation, simply because we have not had a dedicated regulator or enforcer on consumer privacy, federally or in California. We just simply haven't had it.
Right. Well, let's turn a little bit now to who's impacted. And Sadia, maybe you can explain to us if there are any changes in terms of how CPRA now changes the rules in terms of who's impacted, business applicability, if you will.
Yeah, so under the CCPA, and I'm assuming everyone that's listening in, we've all had time to digest that law. We know that the key, one of the key definitions was what's a regulated business. So the CCPA uses the term business over and over again and imposes obligations directly on businesses. So there was a lot of focus initially on, well, what qualifies as a business? Under the CPRA, the definition, it follows closely what was under the CCPA, but it made a couple of changes to the 3 threshold criteria. So I'll back up and, so we say under the CPRA today, entities qualify for business if they are a for-profit entity that collects California consumers' personal information, if they control the means and the purposes of processing that information, and if they meet one of 3 possible thresholds. And so the threshold is where those changes come into play. One of the thresholds was the business has to have gross revenues in excess of over 25 million. That provision is the same under the CCPA and the CPRA. So that annual revenue threshold hasn't changed. One of the second thresholds was the business deriving at least 50% of annual revenue from sharing or selling the personal information of California consumers. And so this is a change in the sense that it now includes the sharing of personal information, which is another new definition under the CPRA. And I know Brandon's going to have the opportunity to tell us all about what sharing is and how that really impacts the ad tech sector. But this threshold, it really changed. I think it expands the businesses that come under the coverage of the CPRA, particularly impacting those in that ad tech sector, again, because of the definition of sharing. And so the last threshold, and I think if I didn't say it before, is you only have to meet one of these 3 thresholds and the previous part of the definition to fall within the scope of the CCPA and the CPRA. And the last one was if your business buys, sells, or shares the PI of more than 100,000 California consumers or households. And so this provision has been changed. It used to be 50,000 and it is now 100,000 under the CPRA, which means that it really heightens the threshold and that more smaller businesses might be outside the scope of the CPRA.
So a little more cover than before, but generally still fairly aligned with CCPA. Yes, is that fair to say?
Yeah, I think so. And, I think one of the things for me, when I used to looking at the CCPA, I think what we're going to see difference is, at least the way, we were interpreting it, is the obligations were always imposed directly on businesses under the CCPA. There was references to other types of entities like a service provider, but still the obligation were always directly imposed on a business. The service provider obligations really flowed indirectly through contract. And I think, one of the things for me that jumps out is that we start seeing the obligations on service providers a little bit more under the CPRA. And so, in terms of applicability, the definition of business has changed a little bit, but more what I think is important is, I think service providers should pay a little bit more attention to actually the text of the law as opposed to their contracts, what obligations might be directly imposed. We have new obligations there's a new term for contractors, similar to service providers still, but that's a new concept as well. And for one of the things that I actually like was there's some clarity around what's a third party to under the CPRA. And I think there was a lot of confusion early on about what the heck is a third party under the CCPA. And now, I think we've all reached that conclusion that even a business could be a third party under the CCPA, and the CPRA clarified that. So I think this is a good time, if there's any confusion about the different types of entities, take a look at the new text and see if it aligns with what you thought under the CCPA.
Great summary. Thanks so much. We got to get into the data, so let's open it up. This is where, you can't talk about privacy without talking about the data itself. Lily, tell us a little about this employee data and the B2B moratorium about this data.
Mm-hmm. Well, the good news for the employers and companies in the B2B space is that there's currently an exemption for collection of employee data in the normal course of recruitment and employment. And there's also an exemption for B2B data in the normal course of providing services or conducting due diligence on other businesses. This was an exemption under the original CCPA that was set to expire January 1st of 2021. It was kicked back another year due to a recent amendment, and then CPRA pushes it back even further to January 1st, 2023, again, with that 12-month look-back period. One thing, though, is that you can't completely rest easy because the exemption is still fairly narrow. Again, this is information that you're collecting in the normal course of recruitment and employment. And if you're an employer and you're using that information for other purposes like marketing or sharing of data with other parties, then you're still subject to all of the other provisions of CCPA and CPRA. And that's the same thing with respect to B2B data. If you're collecting information outside the course of conducting due diligence or providing services and engaging again in that marketing or sharing of data, all the other provisions apply. One other interesting exemption under CPRA, well, it's actually not under CPRA, but under a recent amendment to CCPA, is the exemption covering de-identified health data. And this is a giant exemption. And the reason there's not a lot of focus on this is that it wasn't passed through the ballot initiative or CPRA. It was passed through an amendment in the last legislative session and kind of went under the radar. And so what this exemption does is that it doesn't count as personal information de-identified health data that falls under the de-identification standards of HIPAA. So under HIPAA, there's two different de-identification standards. One is one where you remove a whole bunch of different identifiers, and there's a list. You can look it up on the HHS website for the exact identifiers that you can remove from a data set to de-identify it. This is fantastic because it's called a safe harbor, exception. And if you can clean data, then it doesn't fall under CCPA, it doesn't fall under CPRA. The second exemption is the expert determination. So if you know someone who is fantastic at statistics and might be good on the witness stand, and they can testify up and down that this information cannot be re-identified and it's de-identified data, once again, you fall outside the scope of CCPA and CPRA. Again, like everything under these laws, there's a caveat. If you try to re-identify the data by combining de-identified healthcare data sets, you fall back in within the scope. So for companies that are trying to be clever and then they send it to a third-party analytics firm that then creates profiles from that de-identified data, you're covered again. And then something else to consider is that if you are planning to use this exemption, please make note of it in your privacy policy.
Would you do us a favor and recant that particular carve out and how people could go to HHS to refer to that exemption on basically the health information? Because I think that's a great carve out, right? Especially if you are, as even a business, collecting some information, say on the shop floor about health data or conditions like that. Could you please review that for everyone?
Definitely. So if you go onto the HHS website, a lot of acronyms.
It's a trick. I just wanted to say it again. Yeah.
There is a whole bunch of guidance documents, and there's guidance documents for consumers, and there's guidance documents for covered entities. And so in that set of guidance documents, you can actually just do a quick search for de-identified data, and it'll pull up HHS guidance on that topic. Some of the guidance is more expansive than others. So for certain elements like names and date of birth, it's easy to clear that out. But then for some other data elements like zip codes, you need to pay a little more attention to what geographies you're collecting the zip codes from, because that might tell you the number of digits that you need to remove from a zip code to make it de-identified.
Great. Thank you for that. I will always try to point out privacy hacks when they come up. And while that's not a hack, it's certainly a very helpful thing to understand if you're concerned about being attacked on that data. Brandon, we've actually got a question that I'm hoping you can help. I think most people on the call or on the webinar are aware of personally identifiable information. But before we get down to talking about the sensitive data that was identified by CPRA, would you please just kind of refer us to the stuff that's not so obvious that falls under PII?
Sure. Yeah. So the regulated data set under the CCPA, and this continues with the CPRA, is personal information. You can call it PI. This is massively more broad than traditional concepts of PII. Traditional concepts of PII is data that in and of itself is identifiable. So your social security numbers, your telephone number, your address plus name, things like that. For PI, personal information, it's really any information that is potentially relates or reasonably relates to an individual. So the information in and of itself doesn't necessarily have to be able to identify a person, but in combination with other data or other technology applications, it's possible to relate to an individual person, not even necessarily an identifiable person, but an individual person. So it's huge. And the CCPA famously doesn't help us a ton. There's not an exhaustive list of data types that are and aren't PI. It's really defined in the abstract. There's a bunch of examples, but even for the examples, they say, well, this may be PI if it conforms to the definition, right? So the question here, I think, zeroed in on, for instance, IP address, where there is some debate, but I think it's probably safe to say I invite any of our brilliant co-panelists to disagree or provide some thoughts. But I think it's safe to say at this point that is considered personal information. We hope, of course, to get some clarity. We got close to getting some clarity on that from the Attorney General during the proposed regs, but they actually withdrew the clarity that they had provided, so we don't have it anymore. So it's just been pretty funny to watch. But Look, in an abundance of caution, treat everything as personal information if you can. But it's always this kind of weighing exercise where you're asking, okay, what's the business interest? What's the business impact? If we define this as PI, if there's no impact, define it as PI, if there's any question, is what I typically say.
Yeah, so the IP address comes back to haunt us when we start remarketing, right, with ad tech, which we're going to cover a little later. But I got to touch on one. We were wrestling with household information. Is it still live? Do we have to worry about people in the household, renters, utility bills as PI?
Yes. So it does still live. There are some kind of changing obligations surrounding what you have to do with a household, but yes, it's still in the definition. So the way it's in the definition is it's any data that can relate to not only an individual, meaning a California resident, but a household, right. A household of individuals.
Good. Well, we know CPRA opened up another can of data, a data type. Tell us a little about sensitive data according to CPRA and how it sort of should inform us going forward.
Sure. Yeah. So, and this is kind of big. So, if anyone wants to chime in, please, by all means. So one of the probably biggest operational lifts of the CPRA is that there's a new subcategory of personal information called sensitive personal information. Maybe we call it SPI. If you're familiar with European privacy regulations like the GDPR, you're familiar with this concept, but we didn't have it in the CCPA. So essentially, it's a subset of all the data I just defined that is defined in the statute as being particularly sensitive, and for that information, additional obligations apply. So we could really go on probably for an hour about this, but to give you an idea of what's in SPI, it's information that they say so first it has to be personal information, but it's any personal information that reveals certain things, including social security number or government ID numbers, account login information, financial account information. There's this concept of precise geolocation that's quite interesting. It's defined as a geographic area that's the equivalent of like a circle with the radius of 1,850 feet. So it's very precisely defined. It's a lot of fun, for us to deal with. It's comparable to some of the advertising industry standards that we see out there. So, they did put some thought into it in defining it that way. But if you're processing geolocation to that degree of precision, then it's considered sensitive information, and there's going to be just additional things that apply. So if your technology can, geolocate at 1,851 feet, then your life is going to be a little bit easier. So I mean, I'm happy to open it up to other folks, but the obligations that apply are basically enhanced disclosures in your privacy policy for SPI. An ability to opt out of certain secondary uses of that SPI. So kind of basically you can request that the company not use SPI for any purposes that are not kind of related to the purpose for which they were collected. As well, there's additional disclosure obligations in response to a request to know. So Karina, Sadia, Lily, I'm happy. What else do you guys think about sensitive information? I know it's a huge kind of topic in this.
I just want to say my fire alarm in my building just went off as planned and expected. So there's going to be this lovely ringtone in the back.
It wouldn't be 2020. It wouldn't be 2020 without a fire alarm.
You know what? Before that happened, I've been waiting for the heater guy to come for like 3 days, and now he's knocking at. I was like, no, not right now. But there's just if it gets too annoying, just tell me and I'll stop talking. But Brandon, I wanted to add to your point about the personal information and the IP addresses. And I think they followed up on the question about what about like a VIN number for a car. And I think, I think it really matters on how you store that information too, because the definition of personal information really talks about, is it reasonably linked directly or indirectly to a consumer. So, we've actually dealt with this question where let's say you just get a list of VIN numbers. That information just in and of itself, if it's not linked to a particular consumer, I think it's arguable that, if someone were to submit an access request, you can't tie that information to a particular consumer. So is a VIN number just by itself not linked to any consumer considered PI? I would say probably not. But if you're storing that information saying Sadia Mirza's VIN number is this, then that VIN number becomes my PI. at least for the sake of the CCPA. And that's how I think it's important to remember that you're linking it to a consumer, which is a key definition. But I thought I'd add that, and I'm going to stop because my alarm isn't going to.
As Brandon said, it wouldn't be 2020 without these things, right? Let's make sure that, let's just hope most of this is behind us. Lily, did you?
Sorry, I'm going to say, if you smell fire, run. Okay.
Great.
Yeah, we just have learned to ignore the fire alarms that go off, which is really bad for other reasons, but no one takes them seriously.
All right. Okay.
All right. Well, Karina, it's not just about the data. I think CPRA raised the bar with this idea of retention, disposal, management. So, you know, I guess you're living amongst a sea of attorneys. We welcome you. Thank you for lending a little bit of ops charm to this discussion. Help. What are the let's start with data minimization. What are the new requirements? What does it mean?
So two of my favorite things that we did see in GDPR that we don't really have very prevalently in any of our existing frameworks, methodologies, whatever you want to call them, even the regulations, is data minimization and data purposefulness, right? So we saw that in GDPR, and you know, the folks that run our data storage are the folks that love data, right? And they're porters. I mean, there's no other way to say it, but that's what makes them really good at what they do. And the difficulty that we've been seeing in Europe after GDPR is we're asking folks who've built a career to relinquish some of the data that cannot be associated to a practical data business purpose. And they can't keep too much, which too much is a very hard to quantify volume of data. So what we're kind of bracing for with CPRA is to intelligently keep the things that make sense for our business purposes and keep the right amount of data that can be validated and quantified in front of a auditor, as an example, or an examiner of some sort, or even a lawsuit, or whatever happens to, whoever happens to ask you about it. What we are going to see is a shift in how we write our policies, and I'm always going to keep saying, and you know, I'm not going to age myself, but back in the day when, you know, the IBM came out with a 1 gig refrigerator size storage container for $40,000 in the 80s when I started IT. We were really, really selective on the data that we chose to keep. It was brutal. It was brutal. We had to make the decision between, do we keep the personnel information and their payroll stuff, or do we keep the stuff about our clients' finances? I mean, the hard decisions to make. But because data was so expensive, we had to make those decisions, and we had to classify our data, and we had to know exactly where it is. Data now, we have an abundance of it. It's not that expensive to store. What's critical is for you to know where your data is. You can have it internal to your organization. You can send it to a vendor. You can pay a vendor to sign into their licensed account, whereas they take your company's data into their environment. You can choose to store your own data off premises in a cloud environment. Whatever the scenario is, know where your data is. And
well,
then
I'm going to pause here because there's a great question. So let's say I've got a vendor that I use all the time, and frankly, they have a lot of my BI. They store it all the time. But all things being equal, they're leaking data like a sieve. What do I do? I can't, you know, I can only control so much. Businesses are using 70% of the outsourcing, and they've got the data, and they're breached. How is that addressed?
You sit down with the initial contract, and you very carefully understand how they're handling your data. And if it's not sufficient to your requirements, then you write a bridge document, and it'll probably be you have to pay them more money because you're asking them to treat your data in a different way than they do for most clients. But most leaks will occur over years. I mean, most of the big ones we know about, you know, how many millions on Marriott? 500 million. They were leaking for 2.5 years. They didn't even know because they used subservice organizations that stored their data in other subservice organizations, aka cloud providers, right? So I think operationally, number one is know where your data is. Number two, classify your data. Three, start with three. It's really, really important to us. It's operational, so it may change, but I don't have to build a whole moat and a castle around it. Or it's noise data, it's public data, it's stuff that I'm not going to sit and go store and pay somebody to store for me and spend a ton of money putting encryption around it, retention standards. 70% of the data that we deal with right now every day is noise. It does us no good. Get rid of it.
Well, isn't it true that it's more than noise? It's actually a liability, because if you get breached,
Got it.
you have not cleaned out, I'll just say it, my garage is a mess, right? But if you haven't regularly cleaned out the garage, you've got 30 to 40% of stuff, we'll call it personal information, that actually is a liability, because the chances of being breached are high. The question is, are they going to get to that data, right?
Well, in the garage, think about that box of batteries that we go drop into, and over time, what happens with those batteries? They start doing their little fungal thing or whatever they. My neighbor just had a fire in her garage because over the years, you store stuff, you just drop it, you stop thinking about it, and then boom, it explodes. So ask yourself whether you really, really need that data. Now, your data classification is going to give you, for every single type of data that you've now classified, you're going to have the following operational instructions that are going to be the result of it. Number one, retention. How long am I keeping it for? My pizza flyer, I'm purging in 2 weeks. My payroll stuff for my employees, I'm going to keep that. Most people say 10 years. They like to keep it minimum, if not more. But set that in writing. Have a policy around it. Retention destruction, right? When I do delete my classified data, how am I going to do that compared to my noise data? What are the differences in purge? Number three, backup. BCP, DR, backup recovery, where, depends on how old you are, what you call it. But, I used to have a CTO who used to come into the data center and literally flip the breaker. And we learned really, really well how to recover manually and continue our operation. So today we would never allow that to happen. Of course, we have sensors, but you need to know what's the most important thing that needs to come up first. This is going to require talking with your lines of business, understanding what the costs are for outages, understanding who are those key vendors to prevent you from maintaining a very good redundancy rate. And then encryption, meaning you can make a true decision to not encrypt the noise, but encrypt the stuff that's really important, right? So those four things are going to come from your three data classifications. The next thing you're going to do is you're going to do access controls. You're going to take that same level of classification, where your data is now, what the data is, all the principles on how you're handling that data. Your last question is who accesses the data? So access controls, least privilege permissions, segregation of duties for your change management. There's a whole thing there. But if you can hone in on those key areas, you're going to be in much better shape, and most everything will fall into place.
Great advice. Attorneys, before we leave retention, are there any sort of good practices on the hygiene side that you guys would weigh in on? For example, I go chase a particular vertical market or a subsection, and I'm no longer chasing it, but I really collected a lot of data. I want to archive it. I probably, because of Karina's advice, I encrypt that data and I put it in a special place. I'm still obligated, right? I've decided I'm going to continue to be a hoarder. I can't break myself because I might come back to that segment, right? Any advice on how you do that, or the policies you write around that?
So, well, I would say on the privacy side, as it's relevant to CPRA at least, it all comes down to the circumstances through which you collected the data and what your notices say and what your notices said. So if you're hoarding data that you collected for reason A, but you want to use it for some other things, you don't know what they might be, or kind of just holding on to it, that's not a practice that's going to work under the CPRA. It doesn't really work under the CCPA, but it even worse and more directly is a violation of the CPRA, because there's now this affirmative obligation that your collection of information needs to be reasonably necessary and proportionate to achieve the purposes for which you collected it, or for another disclosed purpose. So if you're doing something with that data that's not consistent with the context through which you collected it, or the purpose that you collected it, and your disclosures, then that's now under the CPRA a direct violation subject to penalties.
So you kind of stepped right into it. The bottom line is don't, because you don't have permissible purpose. You're not noticing them. You put them over to the side. That's exactly what the law is trying to prevent.
Right, and the way I wanted to answer it that way though is that operationally there are things you can do to silo the data to make sure you're not using it for different purposes. But if there's an expectation that you're going to use it for purposes A through Z, you can disclose all of those purposes. And if you collected it, with that notice in place, then that is consistent with what the CPRA is saying. So it really is a question, at least for the CPRA, of knowing all the potential applications of the data and making sure that you're being transparent about all of them.
I appreciate that.
And just
I was going to say, sorry, go ahead, Lily.
Just to follow up on that, also pay real close attention to the contracts you're signing with your customers and vendors. I'm starting to see more and more provisions where the customers are actually requiring their vendors to sanitize data to those high NIST standards for sanitization. So you might be holding on to it in violation of a contract. And then the point about encryption, we all know that encryption standards change over time. So maybe something's secure right now, but are you really going to look at it 5 or 10 years down the road where the current encryption standard's out of date and old and someone can access the data?
I was just going to say, I think, I think this is one of the issues that one of the topics that I take issue with under the CPRA, because I think, I think the intent was, we're trying to increase consumer privacy, enhance consumer protection. But what I think it's going to do, it's just going to incentivize businesses to draft very broad privacy policies. And, it's not that, and we already see it. If you review privacy policies today, they look very similar. It has very boilerplate language. Some will call out specific uses, but then there are tons of other bulleted points about how else they're going to use the information. And so to the extent you're using information for a disclosed purpose, it's just going to continue to incentivize people to have these broad policies, which really doesn't give anything back to the consumer, I think. But that is how businesses will ultimately end up using it. And that's how, unfortunately, the law is written. And I don't think it doesn't accomplish what it was trying to accomplish. But the good news is from the business side is that, you should take a look and think forward about how you might want to use the personal information, even if you're not using it at that moment, and cover it in your notices so that you don't have to go back and give a different notice at that time, is essentially the practical advice we're giving. But does it help consumer privacy? I don't know.
All right, well, let's shift our attention a little bit to you again. There was a lot of discussion on this broad discussion of security, right? Reasonable security procedures. Tell us a little bit about what CPRA has to say about securing data and the authority to validate data as well.
Yeah, and this was actually, I was going to raise this, I was looking at the questions too, and that specific question, Brad, that you brought up about, if a business is using a web service and the web service or one of the vendors is breached, how is that addressed? And as you mentioned, I do a lot of incident response. So like 50% of my, maybe even more than 50% of my time is now dedicated to incident response. And what I've realized is that there's a lot of confusion about the CCPA and how that interacts with California's data breach statute. And so, just to be clear, under the CCPA, the obligations that a business that's subject to the data breach statute in California, the CCPA doesn't tell you what to do in the event of a data breach. There's nothing in the CCPA that says, that talks about notice, what qualifies as a breach, or anything along those lines. That is a completely separate statute. And it completely separate to the extent even personal information under California's data breach statute is obviously very much more narrowly defined. It's not the personal information we consider under the CCPA. So, just to answer that question, the CCPA doesn't say anything about that topic. What do you do in the event if your vendors have a breach? Well, you need to look at what your obligations are. You need to look at the particular instance of that incident and see, has it triggered any notification obligations? And so that's outside of the CCPA. That's even outside of the CPRA. And so, Brad, now going back to your question, well, what about security under the CPRA? So, like I said, the CCPA, it's not your data breach statute, and it was never also your information security statute. That's
Right.
a different law in California as well, right? There is a specific law that says a business that owns or maintains personal information has to use reasonable security procedures to protect that personal information. We didn't have that language in the CCPA, but what we're seeing now is that there is, it's being incorporated by reference into the CPRA. So you'll see in sections, I think it comes up right away, right at the beginning, in like section 1798-100, where it says that businesses that maintain this type of information need to use reasonable security procedures to protect that information in accordance with California's Information Security Statute 1798.81.5 or whatever it is. And so I think to me that was pretty notable, given that we have this new enforcement authority, right? Because these are the questions that come to my mind. So if the CPRA says you need to maintain reasonable security procedures, it makes me start to wonder, okay, well, if that's true and we have this new enforcement authority, what rights or what role will the enforcement authority play in making sure that businesses are maintaining those reasonable security procedures? So I'm sure everyone, there's been lots of conversation about, well, first, what are reasonable security procedures? And unfortunately, as with many other things, there's no fixed definition for what that is. It depends on the nature of your business, the size of your business, the data that you collect. So there's not a fixed standard, but there are obviously, we have like the NIST cybersecurity framework and other like building blocks and foundations that organizations use to build their cybersecurity frameworks. But generally, there's not like just a checklist that you can use. Here's what qualifies as reasonable security. So going back to, the authority, I think for cybersecurity professionals, for information security professionals, I think this really raises a couple of red flags. You have this new enforcement authority, and the questions I would ask is, will the agency be able to come in and audit a business for reasonable security procedures? I think that's huge because we don't see too much of that. We have the FTC played that role, but we never had a dedicated body here to cybersecurity and privacy in California. Will the agency be able to investigate complaints related to the failure to maintain such practices? Again, what standard will the agency use to judge these organizations? And it's a good time to point out, at least the California Attorney General has previously provided its view that the CIS, the top 20 CIS controls represents the baseline of information security, at least in California. So I think at least, given these new requirements and incorporation by reference, new agency, I think the takeaway is take a look at your security framework, match it up against, the top 20 CIS controls, since there is at least, that public-facing position that's minimum baseline security, and take steps toward, assuming that this is the type of authority this agency will have, you just want to prepare yourself for that.
So the one thing I want to actually add to that, in addition to the CIS stuff and the regulation things that we have, right? So if I have a business whose product or output has to abide by regulatory requirements, I of course have to follow those. But I think a lot of our confusion rests with your frameworks and your methodologies, and people do try to follow them per diem. And what they need to remember is there's a bunch of folks who are super well-intended, sitting around a round circle for years and years and coming up with verbiage that actually will apply to all regulations, all levels of maturity, regardless of what industry you're in, regardless of how big or small your company is. So they write these frameworks and methodologies for the purpose of them being applicable to everyone. And what you have to do is you have to take them as guidance inside your own company and say, I know my regulation over here that I have to abide by. So I'm going to not, I mean, that's got to be, a federal regulator could show up and audit me on this. I have to follow that. But when I take guidance from a methodology and a framework, I need to say, okay, well, out of these 400 rows, you know, these 175, they really do apply to me. Let me make sure that they are reflective in my policies, are reflective in my processes. And a lot of people will go off and do a pen test, or they'll do some sort of an audit, and they're going to get a SOC 2 or whatever they do, they get ready for that. But they don't grab those artifacts of all of these efforts that they're actually spending money on and creating that logical audit binder, not even for the purpose of an auditor. Just grab your results of all of these tests and put them in a folder so that you have a long-standing trail of, you know, we tried, here's IDSs, IPSs, here's our patching rate, here's our, all of these things that we're doing operationally to keep us safe. You want those in a special location. Just be organized with them.
Yeah, I think it's just the fear that if I didn't comply with NIST 100%, that I'm somehow going to be called in front of the court and said, but that's not the reality, right? The reality,
because it might not apply to you.
Right. So
not all of it.
Right. You take what you can do. You know, the minute you do a pen test, you're going to have some findings. You address them, and you have to put the key here, put together a program over time, have a plan, and at least start executing it. So if you did get called under the mat because something failed, and by the way, stuff fails, right? Malware, ransomware, this is now daily stuff for almost even small business. In fact, medium-sized healthcare companies, ask them what their greatest fear is, and it's ransomware. Attorneys weigh in. Any thoughts in response to Karina's suggestion?
No, I think that's right. You have to take it exactly, you know, these, the NIST cybersecurity framework, these other things, they're frameworks, it's guidance. It doesn't have to be applied, you know, word for word. Some of it will not be able to. It just depends on what your organization's needs are. So you take it for guidance, and it's, you know, it's kind of like when we talk about incident response plans too. You can't just take one off. You know, you can, if you actually Google an incident response plan, you can find a template for it online, print it out, put your company's name on it, but it's not going to work if you don't customize it to your business.
Right.
And so the same thing goes for these frameworks. It needs to be customized for it to have any value. And, you know, you don't have to feel like you have to comply with word for word of it. It's, again, it's a framework, it's guidance, and it's intended to be used as such.
Mm-hmm. Okay, let's turn our attention a little bit to third parties. There has been a little bit of redefining. You know, we compare ourselves a little bit to GDPR here, but California is in its own, say, our own private Idaho, our own private California. Brandon, service providers, now we have contractors, that it's getting a little fuzzy. Help me.
Well, it's always been pretty fuzzy. So, you know, I think one of the biggest kind of structural weaknesses of the CCPA from the get-go was its inflexibility with defining different parties, different stakeholders. You know, basically what they've been saying is you're either a regulated business, or you're a service provider. There's this concept of a third party, open to debate whether those concepts are mutually exclusive or whether you can be both. Now they've introduced a new term of contractor. Now, I don't know how much good it's doing us though. They've kind of like fiddled with the definition a little bit. There's this, you know, kind of acknowledgement that a contractor is someone that data might be made available to in pursuant in the course of providing services to the covered business, whereas a service provider is someone that actually receives that data. You know, so I think some of these definitions are I don't think of great consequence to someone who's not a lawyer that's just really like digging into these into this verbiage. You know, how are we going to be able to maximize the benefit of these change definitions, I think, is something that remains to be seen. They did do a little cleanup in the difference between a third party and a service provider and a contractor. The way that it used to be structured is that a third party was kind of defined in the negative, and it was saying, well, you're not a third party if you're this, and that ended up getting kind of rolled up into the service provider requirements, because of course, if you don't want to be a third party and you do want to be a service provider, you're going to avoid being a third party just as much as you're going to want to fit within the definition of a service provider. So they've done some cleanup here, but I do think it's by and large of interest to attorneys and people that are maybe drafting these contracts, you know, their DPAs, and making sure that all the language is in there to make sure everybody is clear what role each party and counterparty is playing in a given transaction. So that remains the most important goal under the CCPA. You want to clearly define roles. You want there to be no room for debate about who is the party that's ultimately responsible for the data, and which is the party that's acting merely as a service provider. But a reminder, as a service provider under the CCPA and the CPRA, you can still be liable for violations of the CCPA. You are not primarily liable because you're not essentially controlling the data, but if you do something that results in a CCPA violation and you, the service provider, are the only one that is responsible for that violation, then you can potentially be violating the law, and that continues with the CPRA. So that's kind of the reality, depending on what role your company is fulfilling, and often it's both, depending on whether you're providing services or controlling the data. But these concepts as defined under the GDPR in Europe are much cleaner, and I think we still kind of use these terms of controller and processor, even when we're talking about California privacy, just because they're more workable. So unfortunately, I do think it was a missed opportunity to kind of clean up some of this stuff. The last thing, there are some new obligations that attach to both service providers and contractors, which again, there's not much difference between the two terms. They have to notify businesses of any engagement with a subcontractor, so it's kind of cleaning up the downstream flow of data for purposes of providing services. Businesses need to contractually prohibit service providers and contractors from combining the personal information that they receive with other personal information, is another kind of explicit requirement. And then there's this kind of new direct obligation that service providers and contractors cooperate and assist covered businesses with privacy rights requests. That was something that kind of indirectly was true under the CCPA, but now it's a direct obligation. So service providers do have to be thinking about, what are we doing to comply with our clients' requests that our clients might receive, whether it's a deletion request or a right to know request.
With it, some new audit requirements or certainly new obligations. Lily, do you want to explain what those might be under CPRA?
Definitely. And I think these new obligations will affect a lot of people in the audience right now. So previously in GDPR, there was an audit right, and the right wasn't very well defined. And now CPRA has imported that audit obligation into CCPA. So now if you are engaging with a contractor or a service provider, you need to have the ability to do an audit at least once a year. What's interesting, though, is that the audit provision in CPRA is more expansive than just the term audit. It says, including but not limited to ongoing manual reviews and automated scans, and regular assessments, audits, or other technical and operational testing. So this is really tricky because what often happens is that lawyers are the ones that draft the contracts, and they're the ones that draft those giant security schedules and vendor schedules. They get pushed downstream onto so many different vendors, and it's not a one size fit all situation, like Karina has mentioned before, like Sadia has mentioned before. And it's frustrating because if the legal team and the IT or security team are not aligned, this can create really bad results for the downstream vendors. For instance, what is the definition of an ongoing scan or ability to assess the systems? Does this include an external scan of the network, or is this something as in-depth as an internal pen test of your systems where your customer can come in and essentially look through your entire infrastructure? Mm-hmm. A lot of these risks are things that people don't think of until they have a security incident, and suddenly they have hundreds of customers or thousands of customers diving through their systems. So on one hand, the definition is broad, so that's bad when you're trying to draft contracts and negotiate. On the other hand, that does give flexibility for parties to place reasonable limits on what these audit rights are. And so if you are the CISO or head of IT, please talk to your lawyers and make sure you haven't agreed to essentially show your customers everything under the sun.
Great advice. I don't know how I would actually do that. I usually lose when I talk to lawyers in terms of scope, but I appreciate the idea. we have a lot more to cover and very little time to do it. And I apologize to the audience for not managing our time better, but I love where we're going. We have some new consumer rights, Sadia, that I think we'd be remiss in not covering. You want to explain what those are?
Yeah, so, I'll touch on, I think we've touched on a couple of things throughout the presentation, but I'll touch on two things that jumped out at me is, one, so under the CCPA, we had the notice at collection requirement, right? And it's basically for businesses collecting personal information, you need to provide consumers with a notice at or before the point of collection, basically outlining the categories of personal information that you're collecting and the purposes for which information is being used. The CPRA builds on that. It adds to those requirements. And practical steps is I think the things that you'll need to look at in your notice is you also need to, in addition to indicating the categories of information you've collected and how you're using it, the purposes, you need to indicate whether such information is going to be sold or shared. And you're just visualizing this, and based on everything that we've seen, what organizations have been doing, I mean, I visualize it as being, it's going to look like a chart, basically. Shared, sold, X, and check marks is what we're going to see a lot of. And again, this is I said it before, and this is, the way that the CPRA, CCPA requires disclosures, I don't know how much value it's providing to consumers at this point, just because, these added, making the privacy policies even longer, additional disclosures. I don't know how many consumers are reading it. They look, essentially to me, I've seen, they look the same. And so I don't know what it's doing, but, there are these added obligations. Brandon covered the topic of sensitive personal information. And so the notice at collection requirement also calls that out as a separate category and says, if you're collecting sensitive PI, you need to disclose that same types of information, which is again, the categories of sensitive information you're collecting, the purposes for which you're using it, and then whether or not such information is shared or sold. And then one of the newer requirements is the length of time a business intends to retain each category, or if that's not possible, it said, the criteria used to determine such period. So we'll see practically how that gets enforced. I think we'll see a lot of businesses using that latter language about the criteria used to determine that period, but those are the new obligations with respect to the notice at collection. Karina already covered the data minimization that came out. That's also stemming from that same section, section 100. With respect to, we have the CCPA right to delete. There were a few modest changes to the right to delete. Specifically, under the CCPA, businesses were required, upon receipt of a deletion request, the business had to delete information that they received from the consumer and also notify their service providers to do the same. Brandon covered the definition of a contractor. The one notable thing for me, though, was that, the CPRA says once you get a deletion request, you also need to notify all third parties to whom the business has sold or shared personal information to delete the consumer's personal information, unless this proves impossible or involves a disproportionate impact. Karina is shaking her head, and I think all of us are shaking our head. We saw language like this with the CCPA. You guys might remember with the notice of right to opt out. And originally when the CCPA came out, I had some language in there about you need to go back 90 days and inform businesses who you've sold information to, and let them know that the consumer has opted out. And it honestly, it was a huge obstacle, I think, for businesses to operationalize that requirement. And it ended up getting struck from the CCPA. So that doesn't exist anymore. I think it'll be interesting to see what happens here with the right to delete. My guess is that, and I love guessing on these things, to see how this is going to develop over time, is that we're going to end up seeing the language might not get deleted, but this, involves disproportionate impact. A lot of businesses are going to rely on that. Unfortunately, disproportionate impact is not defined, which actually might be a good thing, because sometimes I think, the grayness in the law, especially when it comes to the CCPA and CPRA, works to businesses' advantages as opposed to when it's a very strict and black and white requirement. But I predict that we're going to see a lot of businesses rely on that type of language.
Okay. Well, thank you for that. I want to honor some of the questions that have come on, especially about public data, social media data. I thank you for asking them. And I wanted to give Brandon an opportunity to sort of address them. I mean, there's many questions. We're not going to have enough time to address them all, but you brought up some really cool points. Brandon, why don't you wax on these?
Yeah, just really quickly, because we did discuss the definition of personal information, and there's a bunch of questions here about data that's gathered from public sources, open source intelligence type data. This is actually a place where the CPRA has kind of meaningfully helped us out. Now, again, this isn't going to help us until 2023, but the CCPA does have an exception for publicly available information, saying that, okay, if it's publicly available, it does not constitute personal information. However, it was defined quite narrowly to include only information that was made available by government, essentially government entities. So when you hear publicly available information, you think one thing, but no, it was actually defined quite a bit more narrowly than you would think. The CPRA does, though, include that in the definition, but it expands it quite a bit to information, and this is more legal language that is defined in the abstract without the benefit of specific examples, but that a business has a reasonable basis to believe was lawfully made available to the general public by the consumer or by widely distributed media. So this is going to be really useful. There's another component to it. It's an or, and it's or information made available by a person to whom the consumer has disclosed the information if the consumer has not restricted the information to a specific audience. So it's going to go back to kind of notice and consent. But this language is going to be able to be used for the benefit of companies that are collecting, publicly sourced data. Now, when you start combining it with other, data from other sources, you still are going to probably have issues. But this is a positive development, and it does expand the available definite exceptions to personal information.
Cool. Well, we have time for one more topic, and Brandon, you win because it's about these contexted behavior ads, right? What if you put your toe in? Will it eat you alive? Help me.
Okay, a minute to talk about cross-context behavioral advertising.
No. We're gonna run over. I just think it's important. This is a pretty big area. Give us sort of the highlights of what the law is talking about and where we're headed here. I think that's the best you can do in 5.
Yeah. So I think Karina has to drop. So
thank you, everyone. It was great to be on this call with all of you. I appreciate all of your amazingness. Have a great day, everyone.
All right, we're going to continue on for another 5, folks.
Okay, great. So here's what's going on. So information that is shared with third parties or collected by third parties for the purposes of online advertising. So we're talking about context-based behavioral advertising has been a touchy subject under the CCPA because there's an argument that type of sharing, if you can even call it sharing, constitutes a data sale under the CCPA, which if it does, it comes with additional obligations, the right to opt out, which can be burdensome to implement, especially with respect to this kind of data, web tracking data, that oftentimes the regulated company doesn't even see or handle, right? So this has been a hotly debated topic. What the CPRA does is it comes out and says that kind of sharing is regulated, and they're defining it with the word share. So they're saying this is called sharing. So when you see sharing under the CPRA, it's not just any transfer of data. It's specifically defined as cross-context behavioral advertising activity.
Mm-hmm.
So now consumers are going to have the opportunity not only to make a request to opt out of data sales, which retains mostly the same definition as under the CCPA, but also not to share information, which is a targeted request specifically at cross-context behavioral advertising. So that's what's happened. It's a fairly big development, but it's kind of akin to just a confirmation that sales does equal this type of activity.
Great, thanks for that summary. We have unfortunately exhausted our time, and I apologize as moderator, but I just, we've got experts in front of us. It would be a shame not to listen to them complete a sentence and hurry them up. So on behalf of ISSA-LA, I want to thank Karina as she left before. Sadia, Lily, and Brandon, great insight. And Rich, I think you can hear, you're probably going to have another webinar on this topic, as things, it's evergreen, but these things are still crystallizing. And I think a lot of changes are afoot, at least through July of next year. As well, we're going to have a new AG, right? We know that, and the committee or the enforcement groups coming in. So back to you, Rich, to sort of wrap this one up.
Well, listen, I want to give my deepest appreciation to the entire panel and also to the folks on the board who helped put this together. I think you've helped the community get a better grip of what this is all about and some of the steps they're going to have to start taking and the thought processes they're going to have to be engaging in moving forward. And yes, we will have to have another one of these between now, maybe two, between now and when this law kicks in, because the impact can be quite dramatic for a lot of companies. But again, you've done a great service to everyone today who's in California and who does business in California. And moving forward, we know we've got some wonderful people like yourselves to refer to. Every one of you is on LinkedIn, so those of you watching can reach out. If you have questions, if you cannot, for some reason, find the people and you have some questions, you can always come to us in ISSA and we'll help connect you. So we've been proud to put this on. We want to wish everyone a fantastic holiday. And remember, you have one last chance to interact with us on December 30th, where we say, go to hell 2020, and we enjoy ourselves with a social hour or 2 or 3. So please do sign up for that. If you can't make it, we wish you and your families a safe and wonderful 2021, guaranteed to be a better year. And so with that, again, a big thanks. So long, everybody.
Thank you.
Thank you.